Good evening, everyone. Can you hear me? Yes. Good. Welcome to the Huffman Lecture, the 11th annual. Hey. We could never have the Huffman Lecture. I'm Jennifer Johnson, Dean of the Law School. Also, a very special welcome to our speaker, Nadine Strossen. Thank you so much, Nadine. And our moderator, Kerry Tymchuk. Thank you. So this lecture series honors the contribution of Dean Emeritus Jim Huffman and the Western Resources Legal Center, an organization that Jim founded during his deanship, which provides practical training for our students in natural resources law. The executive director of WRLC is Jessie Baird. There she is, Jessie. Thank you, Jessie. Yes. Now, tonight's event is sponsored by the Law School, the generous contribution from Voices of Liberty, housed at George Mason University, which focuses on the role of free speech in advancing civil rights in the United States. So back to Jim. Jim spent nearly 4 decades at our law school as a valued member of our faculty, and he served as the dean for 13 years. Now I'm serving as my 10th and final year, and I can say 13 years is quite remarkable. And among Jim's most important contributions to the law school is teaching and scholarship, which spanned areas such as property rights and resources, free market economics, and constitutional. So former students and friends of the law school decided to honor Jim's work by funding this lecture series upon Jim's retirement. And we'd like to thank our 5 donors, 2 of whom are with us tonight, Rick Son and Steve Wellies. Would you 2 stand up so we can thank them? And thank you too to our other 3 principal donors, Dan Harmon, Valerie Johnson, and Kerry Tymchuk. And other donors who contributed to this event are listed on our slide, and we thank all of them for your generosity. I also like to recognize 9th Circuit Judge Dearman O'Scanlan, who is here and was our 2017 Huffman Lecture judge. Now, just a few more words about our honoree Jim Huffman before he introduces our speakers tonight. Jim joined the Wilson Huck faculty in 1972 and served as our dean from 1993 to 2006. He taught a variety of courses here, including constitutional law, natural resources law, and water law. And among his many accomplishments were the securing of funding and overseeing the building of our LEED certified wood hall. Jim is a well-published author. In addition to numerous law review articles, he has authored 2 books. And I know of all of his accomplishments, he's particularly proud of the role he played in the founding of the Western Resources Center, and he continues to serve them. Now, Jim was also the first recipient of the Erskine-Wood Senior Endowed Chair that I probably did. So when I became dean, I promised that at each Huffman Lecture, I would tell a story about Jim. I never thought I'd be the dean for 10 years. Well, some of you might remember stories I've told about Jim in the past, including the story of Jim tackling me in the mud at our faculty touch football game, operative words, touch football game. The infamous Jim golf cart paper. The 2010, too soon, Jim? U.S. Senate election when Jim ran against Ron Wyden and apparently had the election stolen. And the story involving our continuing war on parking when Jim planted a garden in his parking spot and rode his bike to school. Now, given this is my final Huffman Lecture esteem, I'm going to invoke the chair's privilege, whatever that is, but it sounds good. I'm going to repeat one of my favorite stories. So, in the 90s, when Jim was dean and I was a business law professor, I had to go to a conference in Seattle, Washington State Bar Association, and they said, oh, there is a securities law conference last week. I went the wrong week, so I went in the lake, they back in the car, back to Portland, I go see Dean Huff. And I said, oh, you're never going to put together. I'm so sorry. And of course, I will reimburse the law school for the night in the hotel. And Jim goes, don't worry about it. So Jim was Dean, he's already starting to laugh. Research assistant with nice law for pretty much on his staff. The era, most of us remember before the internet, before email. Oh, this is a great conference. It's Watermelon, I think, or maybe the Rocky Mineral Conference in Montana. Jim took time to go. He fills out the form, drops it in the mail, gets on the plane with Montana. Jim did not go the wrong week, went the right week, went the wrong week. So please welcome Jim Huffman.
Well, that's true, except it was Wyoming. And it was in Cody, Wyoming, which proved to be a great place to go because there's a great museum. The Wild Bill Cody. Jennifer's data on the tenure of deans is accurate, I think. And the one thing it indicates is she's smarter than I am. She's getting out after 10 years rather than 13. Well, it's a real pleasure for me to be able to introduce people who I greatly admire. But first I want to say a word about this lecture's connection with the Western Resources Legal Center and the importance of the subject that Nadine addressed, Kerry. As Jennifer mentioned, the principal funders of this lecture were also supporters of the Western Legal Resources Center. And that's how I got to know some of them, some I knew before. So when they said they wanted to do this, I thought I wanted somehow to connect it to the fact that they were supporters of WRLC. And hence we have a very awkward name for a lecture series, but we're sticking with it. And I remain humbled by the fact that people want to do this in my name, and I, as I say each year, and hope to continue to say, I'm very delighted that it's not the Huffman Memorial. I would say that the two people most responsible, I think, for WRLC, I give a lot of credit, but I think the people who really made it happen were Caroline Liddell, who just retired from resigned, got another job, and Steve Wildman. Steve's here, and Steve was our first chair and long-serving chair, and a lot of other people made a big difference, but without Steve and Caroline, WRLC would not be what it is today. I had thought this was the 12th Huffman Lecture, but I don't think Jennifer's word for it that it's the 11th. That means I'm younger than I thought it was. And in philosophical terms, for what it's worth, our lecturers have ranged from Ken Starr to Gerald Torrey. You may not know Gerald, but he's not in the same political camp as Ken Starr. And I'll leave it to you to judge current speakers' political leanings. But my point is, I think we've done what we should do in an academic setting, which is have a whole wide range of views brought public forum. Speech tonight, or the conversation tonight, is about free speech, and I just want to take a second to try to convince you that this is an important topic. Because when I talk sometimes to my colleagues and other people in the academy around the country, I often get the response that, it's really not a big problem. And I think that, the way we hate Congress, we love our representatives, it's the same phenomenon. We we think at home, things are pretty good. And I think they are okay, but not perfect. We've had our ups and downs at Lewis and Clark. We've had controversial speakers. To my knowledge, only on one occasion was there an attempt to cancel that speaker. But in my mind, once was one time too many. And so I think it's absolutely essential that these subjects that are going to be talked about tonight remain a topic that we are focused on. The other thing I would say is indicative of that there is a problem to be dealt with. The American Bar Association, which is not the most forward-looking entity in the world, has put in place a new standard for law schools with, as I understand it from Nadine this morning, with some real enforcement requirements as well. So it won't just be a standard that you say you're doing but don't have anybody checking up to see that you are. So let me then, with that as explanation why I think what we're going to do tonight is really important. Let me just briefly introduce the two people who will be up in these chairs shortly. Kerry Tymchuk served for several years as Chief of Staff to Senator Gordon Smith, I think through his both terms, right? As the Oregon Chief of Staff. And he also was Chief Speechwriter for Dole, which was Secretary of Transportation, and Senator Dole was also legal counsel to Senator Dole, and did a book with Senator Dole on presidential humor. And if you want to find out who was the funniest president, you don't have to buy the book. But Kerry and I agreed this morning that it wasn't Donald Trump. It was Lincoln, right? But most importantly, and I can also say from personal experience that Kerry, and some humiliation, that Kerry is an excellent golfer. But most importantly now, he's the executive director of the Oregon Historical Society and has taken that organization, in my humble opinion, from a good historical society to one of the very, very best in the United States, and has orchestrated a lecture series which maybe reached its peak last night with over 2,000 people to hear Liz Cheney speak at the Schnitt. So, and he kind of warmed up for today by interviewing Liz Cheney. So, and our speaker or interviewee, I guess is the proper term. I won't dwell on Nadine's impressive resume, and it is impressive, but I will note that she is the John Marshall Harlan Professor of Law Emerita at New York Law School, and I dare say that Harlan, were he still alive, would be proud to have his name associated with Nadine Strossen. She served for 17 years as National President of the American Civil Liberties Union through many free speech battles and defending people who other people thought were indefensible. And that's, I think, what that job was all about. In addition, she is on as a senior advisor or senior something with FIRE, the Foundation for Individual Rights and Expression, and is on the boards of the ACLU, the Academic Freedom Alliance, Federalist Academy, National Coalition Against Censorship, at the University of Austin. I think, I don't know if she ever actually goes home. It's only to repack her bag, and she gives something in excess of $200 at a time on this important topic. Nadine is also the author of Hate, Why We Should Resist It with Free Speech, Not Censorship, which was published in 2018. And in 2023, she published Free Speech, What Everyone Needs to Know, which is available from Amazon for $14.47. The last thing I will say, and this is all that really needs to be said, is when Nadine stepped down as head of ACLU, Supreme Court Justices Ruth Bader Ginsburg, Scalia, and David Souter were participants out of that. So I think that is one step our speaker. Thank you.
thank you, and I also want to recognize two other people in the audience. As a law school graduate, I always do talk, but there's a couple of judges in the audience, you introduce them. And we're joined by Ninth Circuit Judge Danielle Forrest, is here with us this evening too, Danielle, so great to see you. And I've also been taught to always introduce my boss, and Jim's wife Leslie is on my board of trustees, and it's one of my bosses and sets my salary, so I also introduce her as well, so Leslie, welcome, so. So Nadine, let's start with a little background about yourself. I mean, I suspect when you were young and growing up, it never dawned on you to say, when I grow up, I want to be the nation's foremost advocate for free speech. Your first being art, when did that first say, this is my passion?
Well, thank you so much, Kerry, and it's such an honor to be here delivering a lecture that's named after one of my heroes who has been a great champion for free speech. And by the way, your boss, his wife, has also been a great champion for free speech and academic freedom. You know, long before I heard the term free speech, let alone First Amendment, I had this innate belief that I should be able to express myself. And I had great resentment about people who tried to thwart me from doing that, including my parents and my teachers. And in all seriousness, when I was a middle school student, I actually became involved in my first public campaign for free speech on behalf of a teacher who was showing students slides of images from the Vietnam War, which was then still extremely popular. And it was very unpopular to be criticizing the war. Now, the teacher wasn't critiquing the war, but he was showing disturbing images of civilians being killed. That led to a campaign by the local newspaper to have the teacher fired. And that led me to start a petition campaign among my middle school students, and those days we called it junior high school. And I wrote my very first letter to the editor to oppose the teacher's suspension. And to this day, Kerry, I care very, very strongly about rights of young people and rights of school students in terms of free speech.
Who won? I'm the teacher.
The teacher got to retain his job. He then actually went on to run for public office. He didn't get elected, but you know, that was the benefit of the students, that he got to stay, remain as a very inspiring teacher.
Now, it'd be great if you said, and his name was Jim Huffman. Is that the answer?
I do want, since Jim mentioned the namesake of my chair, John Marshall Harlan II, when I was installed in that chair for the ceremony, I invited my predecessor as the ACLU president, who was a very esteemed constitutional law professor at NYU Law School, Norman Dorson. Dorson had clerked for Harlan right after he graduated from law school. So I thought, here's a person who actually knew both Harlan and me. And Norman stood up and he was introducing me, and he said, you know, Nadine, you never got to meet Harlan, you never got to meet you. Of course, he died so long ago, but he would have loved you, exactly what Jim said. And I was feeling very pumped up. And then Norman went on to say, Harlan loved everybody.
Well, what better place to address free speech issues than on a college campus, which is, you know, has become ground zero over the debate on free speech, from the Harvard and Penn presidents, in front of Congress, to a Hamline professor who lost his job for showing a slide of a classic art that depicted the Prophet Muhammad. Reflect on the state of play of free speech here on college campuses.
For about a half dozen years now, FIRE, which for 25 years was the acronym that stood for the Foundation for Individual Rights in Education. And let me just add a parenthesis, Jim, you got it right, as many people don't. 2 years ago, FIRE kept the same acronym, but changed the name to reflect and expand its scope. So it is now the Foundation for Individual Rights and Expression, because what starts on campus doesn't stay on campus. And the attacks on free speech that have become so pervasive on campuses have spread to our larger society, culture, government, as college students graduate and take their hostility, at worst, skepticism at best toward free speech out into the larger world. So for about a half dozen years now, FIRE, working together with College Pulse, has been doing a very intensive survey of the state of free speech on university campuses around the country. And it is very distressing. I would say, in addition to the instances of deplatformings and retaliation against professors and students who say controversial things, who address controversial subject matters, the even greater concern has to do with a pervasive climate of self-censorship. So thanks to all of the negative publicity that justifiably rained down upon college presidents who testified on December 5th, it has often been reported that Harvard and Penn ranked numbers 254 and 253 out of a total of 254 in these the most recent free speech rankings. What is very distressing is that the difference between, so there were many vectors that went into the rankings, including policies on free speech, administrative actions on free speech, actual punishment of students and faculty members for exercising free speech. But a major component of the rankings was the campus climate. And this was based on an extremely detailed survey that students took. And of all of the depressing conclusions in this survey, to me, the single most depressing one was that the difference between ranks, the university rank number 1 and the university rank number 254 on that particular vector, whether students and faculty members feel comfortable addressing sensitive, controversial topics. According to the report, the difference was negligible. That even at the top ranked schools, students and faculty members, even tenured faculty members, hesitate to voice opinions that they believe are going to be unpopular, or even to address sensitive subjects. So let me just mention a few subjects where strong pluralities on campuses around the country say we cannot have a frank and candid conversation on our campus about, and the number 1 subject, taboo subject, was abortion. Abortion. Number 2 was immigration, police practices, anything to do with race, anything to do with gender or sexual orientation. And if anything, of course, our campuses should be the places where we have the most robust and vibrant free speech. I noticed that when Jim rightly showed justifiable pride in the ideological diversity of the people who have had the honor of delivering the Huffman Lecture, somebody started clapping, and I was thinking, yes, that does deserve clapping, because it's not something we can take for granted anymore.
Which begs the question, how did we get here?
Well, I would defer to, anthropologists and social psychologists and other cultural critics. I think the best overall explanation that I've seen is in the book that came out a couple of years ago, co-authored by Greg Lukianov, who's the CEO of FIRE, and Jonathan Haidt, a very prominent social psychologist, called The Coddling of the American Mind. And they cite about 4 factors, one of which is the phenomenon of helicopter parenting, or the overprotectiveness and shielding of young people by parents and teachers. And what I find so interesting is that even beyond the free speech reasons why shielding people from offensive or insulting or controversial ideas, while that violates free speech principles. The book also argues that an independently sufficient reason why shielding students from this kind of material is undesirable is that it is bad for their psychological well-being. You think that you are protecting their psyches and their emotions, but you're actually doing more harm than good. That's the expertise that John Hyde brought to the equation. John, in particular, he has a new book out now, believes very strongly that social media has played a major role in bringing about this problem. So there are several other factors.
You're kind of stereotypical, or you got about conservatives who say, aha, we're getting cancer because students protest any kind of conservative speaker who tries to show up on campus. And then liberals will say, aha, it's them canceling us because they're taking library books, looking at curriculum out of schools. Who's right?
Both of them. We in the free speech camp are fond of saying that most people believe in freedom of speech for me, but not for thee, or people who agree with me. Conversely, we in the free speech camp like to cite what we call the golden rule of free speech, that you are never going to have freedom of speech for speech that you love unless it also exists for speech that you loathe. But this is such a bitter pill for people to swallow. Let me tell you, Kerry, I think the strongest illustration of the truth of that generalization comes from the ACLU, the organization I was proud to head for 18 years. I was thinking 13 years, that's no big deal at all. 18 years, but many people who know not very much about free speech still will know what I'm talking about when I refer to the Skokie case. This was a case a famous or infamous case, depending on your point of view, that the ACLU handled in the late 1970s. And when we came to the defense of a group of neo-Nazis to demonstrate in Skokie, Illinois, a town near Chicago that had not only a large Jewish population, but at the time, many of them were Holocaust survivors. Now, I have to tell you, this was an easy case in the courts of law. The case went all the way up to the US Supreme Court. And it was such a clear winner in defense of their right to speak that the Supreme Court did something very unusual. It ruled in favor of the Nazis' free speech rights without even receiving briefs or hearing oral arguments. And this gives me a chance to put on my common law professor hat. What was at stake is what the Supreme Court has called the bedrock principle of our whole complicated free speech jurisprudence, is built on this bedrock principle called viewpoint neutrality or content neutrality, that government may never suppress speech solely because of disagreement with, even loathing of the viewpoint, the idea, the message, the content of the speech. In our democratic republic, if we the people hate the idea, then we should answer back, we should protest, we should counter-demonstrate. Maybe strategically it's better to ignore the message we hate, but it's not for government to pick and choose the good ideas from the bad ideas. So it was an easy winner in the courts of law, but in the court of public opinion, it was so unpopular that the ACLU even lost 15% of our own members, people who are such diehard free speech supporters that they forked out the $20, and by the way, it's still only $20 after all. Yeah, that's it. To become card-carrying members. And they said, we believe in freedom of speech, except this goes too far. And one of my friends who was then the executive director of the National Coalition Against Censorship, Leanne Katz, put it so well. She said, you know, Nadine, everyone has his or her Skokie, but just one exception they want to make for the speech that they consider to be the most loathsome, the most vile, the most dangerous, the most evil. And people ask me, you know, why do you write books about defending free speech for pornography and for hate speech and for extremist speech? Well, it's because those are the controversial kinds of speech where push comes to shove, where we truly are going to have a robust free speech with viewpoint neutral principles respected. We have to apply those standards to the most controversial kind of speech.
It was mentioned the new ABA standards were mentioned. For those who don't know about those, what are they, and you think they're a good thing?
Well, I have a mixed view about it in this sense. So it's a new ABA standard that is imposed on all law schools, recently went into effect, requiring, as a condition of ABA certification for the non-lawyers here, that's pretty essential to be a functioning law school. And it requires that law schools adopt and distribute and enforce policies that protect freedom of speech and academic freedom. It replaces a prior, much bigger standard that simply required that there be a policy about academic freedom. But this is one that has to protect, it expressly says academic freedom and free speech have to be protected, and that message has to be distributed among the law school community, and it has to be enforced. The reason I say I have mixed feelings about it, Kerry, is it's really too bad that that had to be said. And I'm sure the reason that it wasn't said before was the assumption that, of course, we said law schools have to have a policy about academic freedom. Of course, there are going to be supportive policies. Of course, the policies are going to be known. Of course, they're going to be enforced. But we realize now that that cannot be taken for granted. We've seen some very distressing examples of deplatforming at some of the nation's most prestigious law schools.
We're at a private law school. Is there a difference between what a professor can say and do at a private law school as opposed to a public law school?
Great question. So as most lawyers, but not necessarily all lawyers know, members of the general public may not know, the First Amendment with its free speech guarantee only binds government, including public universities and educational institutions. So private educational institutions do not have any direct First Amendment obligation to protect free speech rights of any members of the academic community. Nonetheless, almost every single private higher educational institution, including law schools, has voluntarily chosen to honor the same academic freedom and free speech principles that they would be required to comply with were they state institutions. And FIRE, for example, has brought many, many lawsuits against private educational institutions. And here again is a wonky law professor point. The legal analysis and argument that you make is a contractual one, that the private institution, by laying out in its policies, whether in the recruitment materials or on its website or in faculty handbooks or student handbooks, when it says that it is going to honor academic freedom and free speech principles, that becomes an enforceable contractual obligation.
Disinformation. We're knee-deep in your presidential campaign. Does the First Amendment draw a line between protected disinformation and punishable disinformation?
It's really good that you bring that up, because until recently, I think hate speech was the single most unpopular type of expression that most people wanted to censor, which is why I would love to defend freedom of speech for hate speech. But in the past few years, there's no doubt in my mind that across the entire political spectrum, disinformation in general and on social media in particular has become the major target for efforts to expand government censorial power. In fact, it was one of the few areas, perhaps the only major area of agreement between Biden and Trump last time they ran against each other for president. I assume it will be the same now. But the major difference, which illustrates the problem here, is that they have completely different concepts of what is disinformation and what is not. So I've got to mention one of the two most foundational principles of free speech, the viewpoint neutrality or content neutrality principle. This gives me an opportunity to say what the complementary principle is. So government may not restrict speech solely based on objections to its content, its viewpoint, its ideas. But when you get beyond the content of the message and look at it in its overall context, the Supreme Court has recognized what's often called the emergency principle, that if in the particular facts and circumstances, the speech directly causes or imminently threatens certain specific serious harm, and the harm is not my feelings are wounded by the idea, right? It's not just the content. But the harm can include, and I'm going to give you examples of false speech that do comply with that emergency standard. One is defamation, right? If somebody intentionally tells a lie about somebody else that damages that person's reputation, leading to adverse financial consequences, that can and should be punished. Another example is fraud. If somebody intentionally lies to somebody else and intending that somebody else to rely on the lie to the financial detriment of the person who relies on it, that's punishable fraud. Another good example is perjury. You're lying in a court of law, you're undermining the rule of law and the system of justice. But when we start talking about this vague, subjective concept of disinformation or misinformation, it simply gives the enforcing authority, whether it be at a university or government or generally, gives them too much discretionary power that predictably is going to be used to suppress whatever message is inconsistent with their own beliefs or the beliefs of the predominant powers in the constituency.
Well, if I were a betting man, I might think that the next frontier for the free speech debates is going to be AI. What they can do with AI is phenomenal. And how do you regulate that?
Every new medium presents both great opportunities and great risks. And one of my friends who's also a senior fellow at FIRE, Jakob Michigama, a couple of years ago wrote a wonderful book called Freedom of Speech, A Global History from Socrates to Social Media. And he shows that around the world, throughout history, and every kind of form of government, every region of the world, the same arguments basically have been recurring both for and against free speech. And every time a new medium is invented, certainly going back to the printing press, but I've seen even when paper was invented or when writing was invented, that it was seen as being so dangerous as opposed to the oral tradition. And so the Supreme Court rightly has said that the same First Amendment principles have to apply to every new medium. Now, maybe the factual analysis will change. It might be easier to show that AI would violate the emergency standard. than another medium would. But I think it's so easy for us to focus on the downsides and to overlook the upsides. Among other things, AI will give great capability not only to create disinformation, but also to ferret out disinformation. I also have to say, putting on my educator's hat, that there is no way that even the most repressive government in the world can eliminate every kind of potentially dangerous speech, whether through AI, social media, traditional media, and therefore, it's a little bit like an analogy to me of every other kind of prohibition strategy, including the war on drugs. We're never going to completely eliminate the supply of the dangerous item. And so we have to focus a little bit more on the demand side. Make people stop demanding disinformation, and also help them to recognize it and resist it. And I see that a number of states now have required critical media literacy skills being taught starting at the earliest levels of education.
We're in Oregon, and as you know, the Oregon Supreme Court and the Oregon Constitution, they have consistently interpreted free speech even larger than US, with unable to regulate, strip joints. Oregon, one of the only state, I think, where there's no limit to what you can give a state candidate for office. Your view on free speech and donations to candidates?
I would have to say among liberals at least, but maybe even among non-liberals, that is probably the most controversial speech that I and the ACLU have defended. There's a national public radio show that used to be called IQ Squared, and now I think it's called Open to Debate. And Floyd Abrams, a great First Amendment lawyer, and I made a record on that program by losing the debate worse than anybody has ever done, really. And we were both defending freedom of speech to make campaign contribution, not even to make campaign contribution, but to advocate certain positions. And I think there's just a visceral hatred toward money and demonized notion of evil, fat cat, corporate tycoons that are out there to, whatever you believe in to undermine those goals. So what I like to explain to people, let's take Citizens United, which is such a hated decision. I recently had somebody very candidly say to me, I haven't ever read the decision, but, I think it's evil, and can you respond to it? What I think is so interesting about that decision and the whole series of campaign contribution or campaign finance cases is that 99% of the time, people will make two general critiques about these rulings. And they'll say, the Supreme Court held that corporations are people, right? How often do we hear it described that way? And number two, the Supreme Court has said that money is speech. And the fact of the matter is that the Supreme Court never held either such thing, which is patently ridiculous. But what the Supreme Court did hold, it held unanimously. So what the public and the media object to about these holdings are uncontroversial on the Supreme Court. So bear with me. The Supreme Court has never held that corporations are people, but it has held that people who have free speech rights, also under the First Amendment, have a freedom of association to join together in various kinds of groups, including corporations, not-for-profit corporations, as well as for-profit corporations, foundations, partnerships, etc. And the Supreme Court held in a very important case from the 1940s that this implied freedom of association includes a right that is so important because it enables people to amplify their speech, their message, far beyond what they could accomplish as individuals, especially because they can do so anonymously under corporate or other group form, and therefore they can advocate unpopular perspectives. What was the evil corporation that was involved in that historic case? The NAACP, the National Association for the Advancement of Colored People. As the Supreme Court explained in that context, it was a case involving Alabama, the NAACP and individual people would not be able effectively to advocate against Jim Crow if they had to disband and become, individual identified voices. And so not a single Supreme Court justice, even the blistering dissent that Justice Stevens wrote in the Citizens United case, he completely agreed with the majority that corporations have free speech rights. The second proposition, the Supreme Court has never said money is speech, of course it's not. But what the Supreme Court has said, again unanimously, not a single justice has ever dissented from this basic proposition, is that when government restricts the amount of money you may spend to communicate a message, including a political message, which is especially important in our democratic republic, that constitutes a restriction on free speech, and it must be reviewed under the First Amendment. Now, in fairness, where the debate is, and why the court was split 5-4 in Citizens United, is whether the particular restriction is justified in order to promote some important goals, such as equalizing access to the political process. And that, I would say, is very much of an empirical question, which is very much subject to debate. The title, Campaign Finance Reform, sounds well and good, but from the political scientists I've read, I think there's a lot of reason to believe that no matter how well intended these laws might be, they actually function as incumbent protection measures. So I think when you get into the details, I can't say it in a soundbite, right? But when you actually do read the opinion or understand the concepts at issue, I think all of us who care truly about not only free speech, but equal access to the political process should have some skepticism about the restrictions. So I didn't know that Oregon is free of them. Good for you.
You mentioned the Supreme Court. What grade do you give this court, the Roberts Court, on free speech issues? And is there a free speech case bubbling up that we should be aware of?
I would, it's not just me, but people who study the Supreme Court much more closely than I do in general. I follow the free speech cases quite closely. I think there's quite a consensus that for a number of decades, not just under Roberts, but under his predecessor as well, that we have the most speech protected court that has ever existed. And one of the things that's quite fascinating about that, Kerry, is that for all of the divisions on the court on constitutional law issues, they're polarized, now sadly along partisan political lines. They are by and large unanimous or with almost unanimous with respect to upholding freedom for very controversial speech, including lies and disinformation, hate speech, other kinds of speech that are extremely unpopular among the public, that you'll see public surveys. Fletcher just released one where sadly, Democrats, Republicans, liberals, conservatives alike think that the United States goes too far in protecting free speech, and that offensive speech and hate speech and disinformation should be subject to more restrictions. And part of the reason why I wrote my most recent book was I was asking myself, how do you explain this disparity? On the one hand, justices who have such strong ideological disagreements and disagreements about constitutional law are pretty much unanimous in supporting speech that the public, again, you know, across ideological divisions, it has a pretty strong consensus against supporting. And obviously, one of the distinctions is that the justices are learned in the law. And I have found that the more people know about what free speech principles actually are, for example, what the court has actually held about campaign finance rather than the ridiculous caricatured version that you often get in the media, the more people understand what the principles are, the more they understand about the history that gave rise to them, the more supportive they become. Because the bottom line is that our legal system does allow government to restrict the speech that is the most dangerous, right? Speech that poses an emergency, but it also outlaws the censorship that is the most dangerous, censorship that targets unpopular viewpoints or ideas.
Reminded of the story when Adlai Stevenson was running against Dwight Eisenhower for president, and a lady came up to Stevenson and said, "Governor, I know you're going to win." He said, "Well, how do you know that?" She said, "Because every thinking person will vote for you." He said, "Oh, I need many more votes than that." Well, we're really going to log all the fun here, so we're going to open it up to the audience for some questions, and we're going to do the Oprah gig here.
Take it around. So raise your hand if you got a tough one. And there you go. A couple of them down there.
First off, thank you very much for being with us tonight. A question about two different things you said. You focused a lot on the importance of fighting to protect the speech we load, and you brought up the Skokie example. But at the beginning of your remarks, you said that the college presidents who testified before Congress were rightly criticized, which I was surprised by, because what famously got them in trouble was not the type of criticism that fire or make college presidents about selective protection, but rather it was Representative Stefanik insisting that they agree that certain Nazi-like speech should be banned, and they resisted it. So it seemed to me you'd be saying she was in the wrong and the college presidents were actually in the right. Isn't it important to be making that point?
Absolutely, and I agree that that particular critique is the same critique that results in people saying we think that offensive speech should be censored. And you know, the phrase, it depends on the context, I think you heard me say, that's what the emergency standard is. That in particular contexts, certain speech can be punished. But what is subject to critique was the pretextual nature of the hypocritical nature of those professions of free speech, when you know that these very same campuses did not abide by those principles with respect to other kinds of controversial speech. They just completely fold into all calls for censorship of anything that made students uncomfortable or that they considered to be insensitive. So they were violating in their actual policies and practices the viewpoint and content neutrality principle and selectively protecting certain controversial, hateful speech, but not others. The other point, I mean, one can be, I think in some ways it's unfair to judge them with 20/20 hindsight, although hopefully they were prepared in advance. I made this point at our breakfast meeting this morning, but I think it's really worth repeating that I have really come to appreciate that if we are to truly have a thriving free speech culture, it is equally important not only that protected, constitutionally protected speech not be punished, but also that constitutionally unprotected speech should be punished. And not to mention that actual assaults and violence must be punished. And distressingly, on campuses, including Harvard and Penn and MIT, there have been video and other documentation of instances of students and other members of the community engaging in assaultive conduct, threatening conduct, or expression, bullying and intimidating expression without any adverse consequences. And that limits the free speech rights of the targeted students, not to mention their freedom of movement.
I also want to echo my thanks to the speaker. Know this is the constitutional law row. One thing myself to constitutional law professors here at the Winston Park. I wanted to talk to you a little bit about this concept of free speech culture and how it relates to the traditional understanding of free speech, legal or administrative fashion. Because the watchword of the latter, and something I very much agree with Brandeis, more speech, not more silence. And that's what you suggested with Skokie, for example. You can't ban this speech, right? The remedy that you should have is to call it out as terrible speech, right? To explain this is awful, racist, anti-Semitic. You should be ashamed of yourself. Hopefully, you feel bad, and you don't do it anymore, right? But then you go to the free speech culture side of things, right? And most of what we're talking about when we talked about, for example, students feeling uncomfortable speaking on campus, we're going well beyond, I'll be expelled or I'll be thrown in jail. Right? What we're talking about is counter speeches that a lot of people will say that do exactly what you recommended they should do. Now you're saying, with respect to free culture, actually this is bad, right? This is a problem, this is a worrisome. So I feel like we haven't fully pulled apart the free speech law and free speech culture, pull us in different directions. And in some ways, compel us to do the thing that we really, as First Amendment scholars, don't want to do, which is to pick the good versus bad speech. And you say, is the speech that we want to make sure you feel comfortable expressing the speech that is controversial, some people say is hateful, and thus we are worried when people say, are too loud in speaking out and saying this is anti-Semitic, and so on. Or do we want to affirm that speech and say, no, we need to have, if someone's calling me racist or anti-Semitic, that's going to sting, you might clam up, but that's free speech too. And I think there's a practical difficulty, but I honestly think there's a conceptual difficulty here when we try to import the legalistic First Amendment principle of viewpoint neutrality into a free speech culture context, which conceptually requires articulations of good versus bad speech.
I don't think it's so much a conceptual difficulty. It certainly is a practical difficulty, and one that I have wrestled with for years. I did my best to try to answer that question in my current book, and I would be delighted to send the Constitutional Row the answer and get your input. If I can say, to use a phrase that we lawyers often use, it is a delicate balance. The title of my book on hate speech is Hate, Why We Should Resist It with Free Speech, Not Censorship. So right there, I am calling for counter speech. But shortly after I wrote that book, I think that was before cancel culture really was talked about very much. It's a fairly recent phenomenon. My friend and colleague Suzanne Nossel, who is the head of PEN America, another group that does wonderful free speech work at the intersection of journalism, literature, and constitutional law. She wrote an op-ed in the Washington Post that was the first time that I really thought of your very excellent question. And the title of the op-ed was, when does counter speech go too far? Not too far in the sense that she would be calling for legally censoring it, right? Although some forms of counter speech, as well as some forms of speech, may be constitutionally unprotected threats or intimidation or bullying, harassment. That's not what she was talking about. It was as a cultural matter, when we're trying to create a community where people engage in robust discourse. How do we draw the line? And I think, you know, one concept which is very common in international law as well as American constitutional law is disproportionality. You know, when the punishment, the social punishment is so disproportionately harsh that it not only stops somebody from, you know, spouting racist epithets, but from even talking about racial issues at all, which is the phenomenon that we've seen on campus. For fear, not only that they are going to be criticized for that particular idea, but that they're going to be excommunicated from the community. They're going to be shamed and shunned and ostracized by their peers, or worse yet, they're going to be suspended or lose their jobs, because we have seen this disproportionately harsh retaliation. But believe me, I think all of us have to have the courage of our convictions. We have to be willing to accept criticisms of our ideas. But I think there's something about our culture, which is often described as polarization, and Haidt and other social psychologists have talked about, he wrote a whole book about how now when you disagree with somebody, it's not only that you're rejecting that idea, it's not only that you are rejecting them as people who have bad ideas, but you're treating them as evil people with whom you do not want to associate at all. So I think we have to build a tolerance. The more I started to think about it, and I would try to write out guidelines for, here are the appropriate norms for discourse in our class. You know, that you have to feel free to voice every idea. You should try to voice it in a way that is not going to be insulting, but you should not ultimately censor the idea for fear of hurting somebody's feelings. Now, I'm not an expert. There are whole fields now of expertise. I think there are mediators and other people that deal with negotiation and complex communications that are now schooling faculty members on how we can have these what they call uncomfortable or difficult conversations. And along with media literacy, I think that these kinds of essential skills have to be taught and inculcated not only in law schools, but at the earliest levels of education.
We had lots of questions.
As a practical matter, what do you think can and should be done about institutional administrations, particularly in colleges and universities, that refuse to take action against student mobs that suppress speech?
Very good question, and that's one of the reasons I have a positive view about the new ABA standards, because they are trying to hold the administrator's feet to the fire, that you got a responsibility to enforce these standards, and if you don't, that's going to be a negative mark when we evaluate you in our periodic reviews for accreditation. It's one of the responsibilities of the leaders of these institutions, and whoever holds them accountable, whether it be a professional organization such as the ABA, whether it be a board of trustees or supervisors, other constituencies, faculty members, alumni, students should, you know, just as when the administration fails to adhere to other standards, this should be a very important basis for dismissal ultimately, some kind of sanction. I'm so tempted to do what I do in law school, but I guess we don't have time. I'd love to say to everybody, what do you think? They're such great questions, and I know you've all thought about them.
One right here.
think the issue. Seeing. Blur. Not an argument. I love Jonathan Hyde. Probably. Hoover argument, I don't agree with the anecdote, but that it's the key, it's not an implication throughout the.
You know, that's interesting that if I can, yeah, okay.
I'm a student of Lewis and Clark, graduate of Lewis and Clark. Both violence. Can you explain why a DEI that requires Soviet style diversity attestation not consistent with other educational? Once you nail that, can you explain why, regardless of how objectionable we find her expression or even her arguments, if Amy Wax is jettisoned from the pen, that's also cultural.
Two excellent questions. So, DEI, you specifically talked about the attestation requirement. There's a whole other subject about, you know, whether DEI as it is actually being implemented is inconsistent with academic freedom and free speech, and that argument is being made very seriously, including by political liberals such as Steve Pinker at Harvard. But specifically on the attestation, the compelled speech, it is completely inconsistent with the First Amendment, as I hope will be held in a lawsuit that was brought by Fire last year against the California community colleges. I know that there are similar requirements all over the country, and Fire picked a case that has particularly egregious facts. I mean, there's a long laundry list of statements that all faculty members throughout that system, which turns out to be the largest college system in the entire country, including they have to attest that even to say that I am colorblind is racist. I mean, there's this long list of statements, and that clearly violates the principle that the Supreme Court upheld so long ago in 1943 in West Virginia Court of Education versus Barnett, long before the Supreme Court strongly protected free speech at all. It upheld the right of Jehovah's Witness school children in World War II not to be forced to salute the American flag, an ACLU case, by the way, I'm very proud to say. And what's so interesting about that case is that the court said that it is even more violative of individual freedom of conscience and freedom of thought for the government to compel you to say something you don't believe. That violates your freedom and your dignity, your self-determination, even more than government stopping you from saying something that you do believe. And the Supreme Court twice in that case, this is a really wonky point, you know, says there's no exception. But we know that there always are exceptions to a government's power to, government may restrict speech if it satisfies the emergency standard. Sometimes lawyers call that strict scrutiny. But as to compelled speech, the court said there's no exception at all. Government may never compel you to say something you disagree with. So I think we're going to win that case. Amy Wax, Penn, of course, has a free speech policy, which has been violated by the proceedings in that case. What I find very puzzling about it is that until very recently, the dean of the law school issued very strong statements that defended her academic freedom and her rights under Penn's policy, and then switched, just did a complete about face. Case is going through litigation now, and as often happens in these situations, other charges somehow are dredged up that never had been raised before. So now, in addition to claims that have arisen, until recently, the complaints were only about extracurricular statements she had made, not in her capacity as a legal scholar, not in her capacity as a teacher. Until recently, there had never been a single allegation of a student complaining of any kind of inappropriate statement, let alone harassment or discrimination in a class. But apparently some such complaints have come up lately, which may or may not be pretextual. There are due process concerns, but to me, the principle at issue completely transcends what any of us think about any of her controversial extracurricular statements. And I'm very proud that the Academic Freedom Alliance has very strongly and consistently come to her defense, as has FIRE and other free speech organizations.
I don't want to squelch anybody's free speech, but we've got time for one more question. Right there.
Thank you. Thanks for being here. One of my partners in New York, Victor Huffman, I'm sure you know him.
And his wife?
Once convinced me that I really didn't want to be a free speech absolutist. Went through some of the arguments that you made. And curious whether you or other serious academics today looking at any other carve-outs like defamation, emergency clause, emergency as further appropriate restriction of
I think that the law, as I tried to indicate, is very sensible. But I did mention that we have new factual context, and your question makes me realize that I didn't completely answer one of your questions, which is, what are the interesting cases before the Supreme Court now? And the Supreme Court has a slew of cases involving social media, and the conundrum that is presented by this fact, and many people are saying this fact, which I'm going to lay out, requires a rethinking and additional government power of regulating speech. And that is the unprecedented power and importance of a few private platforms. So the Supreme Court itself said in a case that's now, I think, 7 years old, so quite a while ago, the Supreme Court said there used to be debate about what are the most important platforms for the exchange of views. Now there's no debate at all. It's the internet in general and social media in particular. So when Twitter and Facebook deplatformed the person who then was still the duly elected leader of the free world, thereby depriving him of that platform, but also depriving everybody else of the right to receive information and ideas, which is an essential aspect of the First Amendment. That's quite disturbing. And at that point, it occurred to me that Mark Zuckerberg had more power to do more damage to free speech than Donald Trump ever could have. Because Donald Trump was subject to First Amendment constraints. He was sued under the First Amendment successfully, but Zuckerberg is not subject to First Amendment constraints. Donald Trump could be voted out of office as he was, but nobody can unelect Mark Zuckerberg. Donald Trump could be impeached, which he was. Nobody can impeach Zuckerberg. And there aren't any of the due process constraints or transparency constraints, let alone First Amendment constraints. So it is interesting to me that an ideologically diverse range of experts, including even libertarians, as well as conservatives and liberals have argued and are arguing in the Supreme Court now that these social media platforms should be treated as regulated public utilities and common carriers and be required to offer equal access to everybody in a non-discriminatory basis. I personally am not persuaded by those arguments, but I think it's a serious argument, and we have to come up with some other response to the so far distressingly unaccountable power over who gets to speak in our democracy.
Jim mentioned what an app for in your schedule. And this morning you shared with us a little bit about your next 72 or 96 hours, which have just tired me already. But share, where are you going to be the next 3 or 4 days? So besides on an airplane, which is where the answer is. So
My next stop is Austin, Texas.
tomorrow.
Yes, for South by Southwest and the launch of the University of Austin. And one of the things I'm going to be doing is sharing a platform with RFK Jr., talking about free speech and civil discourse and the lack thereof in the political process. From there, I'm flying to New York to do a program at the 92nd Street Y together with the New York Times columnist Bret Stephens and the First Amendment lawyer Floyd Abrams, talking about current free speech challenges. And I'm flying out right after that to Colorado, et cetera, et cetera. And I'll get to see my husband, in about 2 weeks. So, as my father said, our marriage is so happy because we're constantly having honeymoons.
Well, we're honored that we have you for the 12th or 13th. You guys will debate that. Jim Huffman Lecture. Jim, do you want to wrap things up at all?
No.
Well, join me in thanking Nadine for